Hello viewers, I am Dr. Ankit Srivastava, Assistant Professor of Law at Rajiv Gandhi National University of Law, Patiala. The topic that we'll be covering today is Economic Theories of Intellectual Property. So let's introduce the topic. The fundamental principle of intellectual property rights is to safeguard the products of human intellect in the same manner as physical properties are protected. The theories of intellectual property rights are instrumental in facilitating comprehension of the rights that are granted and the rationale behind them. It is intriguing to observe that trade secret law, while a subset of intellectual property rights, is substantially distinct from other intellectual properties. This branch of intellectual property is primarily concerned with specific duties and only addresses wrongfulness that is determined by independent legal norms. Consequently, intellectual property theories are pertinent to trade secret law. This lecture will offer a comprehensive examination of the numerous theories of trade secret protection that have been developed by a variety of philosophers, each with a specific purpose and objective. This lecture incorporates 5 theories. The first one is the natural rights theory. It has been construed on the basis of John Locke's idea. The second is the utilitarian theory, which is based on the Benthamite ideal of the greatest good for the greatest number. The third is the deterrence theory, supports morality. The fourth is the ethic and reward theory that promotes the ethical and moral aspects of intellectual property rights. And the fifth is the personhood theory, which was pronounced by Kant and Hegel. In contrast to other forms of traditional property, intellectual property possesses distinctive characteristics. It is non-exclusive and non-rivalrous. Therefore, the current corpus of law that regulates traditional property is insufficient to regulate the ownership, transfer, and utilization of intellectual property. Consequently, the following theories provide support for intellectual property rights. Now let's come to the first theory, that is the natural rights theory. This theory is primarily based on the notion that all individuals have the right to regard their ideas as natural property, as the creation is the result of creator's originality, inventiveness, and effort. The foundation of this theory is the concept of John Locke, a renowned philosopher, which posits that an author has a natural right to his creation by employing his intellectual labor. This is because there is no distinction between intellectual property and traditional tangible property, nor is there any distinction between the rights of the owners of these two types of properties, including the right to enjoy the property, the right to restrict others from using the property, and the right to transfer ownership. This theory is subject to certain critiques, including the temporal limitation of IPR is not addressed by this theory. The use of IPR is time limited, meaning that the objects that are protected by IPR will become public domain after a specific period of time has elapsed. However, the Lockean theory discusses the unlimited duration of proprietorship of tangible properties. The second is the Lockean proviso prevents an innovator from possessing an abstract concept that could influence future innovators. For instance, if an individual is granted the right to ownership of the innovative concept of preparing pulpy orange juice, the remaining innovators are left with a limited scope of discovery in the same field, which impedes their ability to develop a new method for extracting pulpy orange juice. This ownership right will contravene the Lockean principle of creative liberty and equity. The theory posits that an appropriator is unable to capture all the world's natural resources. For example, the entire soy milk production market will be captured by the innovative individual who acquires the right to his or her soybean milk production concept. Therefore, according to Lockean theory, innovators are prevented from dominating the global market with their abstract concepts. The second theory is the utilitarian theory or the incentive theory. So Bentham and Mill, two distinguished economists, created the theory of utilitarianism, which is defined as social welfare. The goal of this theory is to ensure that all policies are universal in nature, thereby achieving the greatest benefit for the largest number of individuals. The primary tenet of this theory is that the economic impact of industrial progress and cultural products can be significant and positive. Consequently, in order to address the necessity of promoting inventions and creations, it is necessary to provide a nominal certification that the results will be superior to the costs associated with the work. Similarly, the incentive theory, as its name implies, verifies the obligation of society to honor innovators and their right to ownership, as it generates revenue for the entire community. The primary critique of this theory is that the utility gains resulting from the impetus of a unique innovation are offset by the losses incurred as a result of exclusive ownership. Therefore, it is necessary to determine whether the advantages of intellectual property rights can be adequately balanced against the detrimental consequences. The next theory is personhood theory. So, Immanuel Kant and Hegel are the primary authors of the personhood theory. The theory posits that intellectual property is the physical representation of an individual's personhood, and as such, the creator must be able to safeguard it. In contrast to other economically driven justifications, the personhood theory offers moralistic justifications for the protection of intellectual property. All intellectual property is regarded as an extension of the creator's will, and as a result, it is a component of the creator's identity and person. Hegel's ideology emphasized the necessity of establishing an intellectual property system that prioritizes the protection of more expressive works over inventions like genetic research. This is due to the fact that expressive works necessitates a greater degree of personalization, which in turn make them a more significant aspect of the creator's identity. The next theory is labor theory. The labor theory is derived from the writings of John Locke. It posits that an individual is entitled to natural possession of the outcome of their labor if they apply their labor to resources that are commonly held. As a consequence of their labor, an individual who invests time, money, knowledge, and other resources in the development of intellectual property must be granted ownership rights. The theory is incomplete without the two provisos given by Locke himself. They are, the first one is no wastage of property which is owned through the infusion of labor. The second is there must be a good amount of property left for others to own and use. So this proviso is typically disregarded when discussing this theory in the context of intellectual property law, as it was originally intended to be applied to physical property. Nevertheless, there are a multitude of scholarly articles on the subject, including those by Dr. Carice Cring and Professor William Fisher, that establish a correlation between the proviso and intellectual property. The next theory is deterrence theory. Now, the deterrence theory advocates for the promotion of morality, virtue and illicit commercial activity. The deterrence theory is derived from the fact that the utilitarian theory contradicts it by rejecting deterrence as a method of obtaining benefits from innovation for the entire society. The deterrence theory is fundamentally based on the fact that trade secret laws impede unethical marketing. Discouragement is the meaning of the term deterrence. The seclusion of a creation, information, etc. is the primary focus of the theory, which discourages misappropriation. The next theory that we will be covering is the ethic and reward theory. The ethic and reward theory, as its name implies, substantiates the exclusive rights granted to the original proprietor of innovation by intellectual property rights. These exclusive rights are regarded as a token of gratitude to the creator for the significant impact of their creation on society. In contrast to the word reward, which signifies validation of the efforts contributed to a particular thing, the term ethics denotes fairness. To put it simply, the ethics and reward theory elucidates the necessity of compensating a creator for their work, thereby establishing the ethical foundation of intellectual property rights. It is important to acknowledge that the ethical and reward theory continues to be associated with the issue of whether the recompense given to creators and inventors for benefiting the entire society is truly deserving of the same. The theory implies that inventors are entitled to rewards. However, it also establishes that they are not entitled to such rewards on a second occasion. Numerous individuals believe that the creators are already compensated due to the exclusive rights they hold to their work. That will also be used as a source of profit for the creator. Therefore, it is evident that the creator's exclusive right to their creation is excessive. This theory must be read in conjunction with the theory of moral desert. Locke's theory validates the right of a creator to appreciate the results of their labor independently. Now, next is IPR and economic development. So, India has implemented a balanced approach to intellectual property rights protection, acknowledging the significance of both promoting innovation and guaranteeing access to affordable products and services. The nation has established a comprehensive intellectual property rights framework that encompasses geographical indications, copyrights, trademarks, and patents. So let's see one by one. The first thing that IPR does is fostering innovation. Innovation and economic development are significantly influenced by IPR. IPRs encourage investment in research and development by providing creators and inventors with exclusive rights. This is particularly important for a developing economy such as India, which is trying to transition from a labor-intensive to a knowledge-based economy. A secure environment for creators to realize the reward of their intellectual efforts is made possible by a comprehensive IPR framework that encourages innovation. This results in an increase in private sector R&D expenditures, which in turn facilitates the development of new products and services and technological advancements. Additionally, intellectual property rights encourage innovation by acknowledging and compensating creativity. This has the potential to motivate youthful entrepreneurs and researchers to pursue their ideas, thereby contributing to a dynamic innovation ecosystem. India has acknowledged the significance of intellectual property rights and has implemented substantial measures to fortify its IPR regime. Patents, trademarks, copyrights, and geographical indications are safeguarded by the nation's comprehensive legislation. These legal frameworks establish a robust foundation for businesses and innovators to safeguard their intellectual assets. Nevertheless, obstacles continue to exist. The innovation ecosystem is still being affected by counterfeit products and piracy, which is why IPR enforcement remains a concern. Furthermore, it is imperative to exercise caution when reconciling the interests of innovators with those of the public, particularly in sectors such as agriculture and healthcare. India must continue to enhance its IPR infrastructure, raise awareness of IPRs, and cultivate a culture of innovation in order to completely realize the potential of IPRs in propelling innovation. India can accelerate economic growth and establish a knowledge-based economy by fostering an enabling environment for creators and inventors to leverage the power of IPRs. The second is attracting foreign investment. Now, foreign investment has been significantly influenced by intellectual property rights. It is imperative for developing economies such as India to establish a robust IPR regime in order to attract FDI or foreign direct investment. The protection of their intellectual assets is a growing concern for foreign investors, particularly multinational corporations. Their innovations, technologies, and brands are guaranteed security by a robust IPR framework. This in turn motivates them to allocate resources to manufacturing facilities, technology transfer, and research and development within the host country. India has acknowledged the significance of intellectual property rights in attracting foreign direct investment. The country has implemented substantial reforms to fortify its intellectual property rights regime, such as the establishment of specialized IPR tribunals and the alignment of domestic IPR laws with the international standards. India has emerged as a preferred investment destination for numerous global companies as a consequence of these efforts, which have yielded positive results. Additionally, India can advance in the value chain with the assistance of a robust intellectual property rights regime. India can foster domestic innovation and entrepreneurship by safeguarding its own intellectual property. This in turn may result in the creation of novel products and services that can be exported to global markets. Nevertheless, it is imperative to maintain an equilibrium between the protection of intellectual property rights and the promotion of affordable access to technologies and medications. This approach is illustrated by India's mandatory licensing provisions for essential pharmaceuticals. The third is technology transfer. Technology transfer is a critical element of economic development, and IPR are instrumental in facilitating this process. IPRs foster research and development by providing innovators with exclusive rights, thereby facilitating the development of new technologies. Consequently, this promotes the transmission of technology through a variety of channels. Initially, intellectual property rights have the potential to attract foreign direct investment. Multinational corporations that possess sophisticated technologies are more inclined to invest in countries with robust IPR regulations in order to safeguard their intellectual assets. This influx of FDI not only provides capital but also managerial expertise and cutting-edge technologies. Secondly, intellectual property rights facilitate technology licensing agreements. In exchange for royalties or other considerations, these agreements enable technology proprietors to authorize others to utilize their intellectual property. This mechanism allows Indian companies to access foreign technologies without incurring the high costs of independent research and development. Additionally, intellectual property rights can encourage partnerships and collaborations between domestic and international entities. These partnerships can expedite the transfer and development of technology by combining resources and expertise. In sectors such as pharmaceuticals, biotechnology, and information technology, India has observed an increasing number of such collaborations. Nevertheless, the connection between technology transfer and intellectual property rights is intricate. The diffusion of technology can be impeded by the imposition of excessively stringent intellectual property rights protection, which results in an increase in the costs of technology acquisition. This is especially pertinent for developing nations such as India, where economic development is contingent upon the availability of affordable technologies. In order to resolve this issue, India has implemented measures such as compulsory licensing for essential pharmaceuticals, which aim to strike a balance between ensuring public access and incentivizing innovation. The fourth is balancing interests. So the IPR regime of India is inextricably attached to its transition to a knowledge-based economy. Although robust IPR protection fosters innovation and attracts foreign investment, it also presents obstacles to reconciling the interest of consumers, innovators, and public health. Robust IPR encourage research and development, resulting in the development of new technologies, pharmaceuticals, and products. This promotes economic growth and employment creation by fostering a competitive environment. Furthermore, multinational corporations are considerably more inclined to invest in nations that safeguard the intellectual assets when they are safeguarded by an effective intellectual property rights framework. The enactment of comprehensive IPR laws and the establishment of specialized IPR tribunals have helped India make substantial progress in the enhancement of its IPR infrastructure. Nevertheless, access to essential products and services can be impeded by excessive IPR protection, particularly in the agricultural and healthcare sectors. There are millions of individuals who may be unable to access life-saving medications due to the high cost of drugs, which is a result of patent protection. In the same way, the safeguarding of traditional knowledge can impede the ability of local communities to utilize their own resources for subsistence and livelihood. India has implemented mechanisms such as compulsory licensing to address these concerns. This mechanism enables the government to authorize the production of patented products without the patent holder's assent in specific circumstances. Additionally, the enforcement of IPRs remain a challenge in India. The economy is harmed and the efforts of innovators are undermined by the ongoing prevalence of counterfeiting and piracy. In order to safeguard the rights of intellectual property proprietors and guarantee a level playing field for businesses, it is imperative to enhance IPR enforcement mechanisms. Now let's talk about challenges. Balancing innovation and access. The dilemma is exemplified by the pharmaceutical industry. Although intellectual property rights stimulated pharmaceutical research, they also resulted in exorbitant drug prices, which restricted access to millions. India's compulsory licensing provisions have been a step towards resolving this issue. However, they continue to be a topic of controversy. The second is enforcement challenges. Enforcement continues to be a substantial obstacle despite the existence of robust intellectual property rights laws. The value of intellectual property is being eroded and innovation is being discouraged by the prevalence of counterfeiting and piracy. The third is traditional knowledge. Another intricate issue is the preservation of traditional knowledge while simultaneously reconciling the interest of commercial entities and local communities. India's endeavors to establish a unique system for traditional knowledge are still in the process of development. The next is small and medium enterprises. Although intellectual property rights are essential for large corporations, small, medium-sized enterprises frequently lack the necessary resources to safeguard their intellectual property. This can impede their competitiveness and expansion. Now let's talk about the opportunities. The first being leveraging traditional knowledge. India's extensive collection of traditional knowledge has the potential to stimulate economic development and innovation. The establishment of new markets and the generation of revenue for local communities can be generated through the effective protection of intellectual property rights for traditional knowledge. The second being geographic indications. Rural economies can be benefited by safeguarding geographical indications, which can increase the value of agriculture and handcraft products. The third being open innovation. By promoting collaboration among academia, industry and government, India can cultivate a culture of open innovation. This has the potential to result in the creation of novel solutions to societal issues. Fourth is IPR awareness. It is imperative to raise awareness of IPR among policymakers, enterprises and the general public. IPR's education that is effective can foster innovation and safeguard intellectual property. Now let's talk about way forward. India requires a nuanced approach to intellectual property rights that effectively balances the interest of consumers, innovators and the public. It is imperative to invest in research and development, provide support to SMEs and strengthen IPR enforcement. Furthermore, the investigation of alternative intellectual property models, including user-generated content and open innovation, can generate novel economic development opportunities. Ultimately, India's success in utilizing intellectual property rights to drive economic growth is contingent upon its capacity to establish an ecosystem that promotes innovation, safeguards intellectual property, and guarantees equitable access to knowledge and technology. With this, we come to the end of our today's lecture. Thank you very much.